Good evening, everyone. Welcome to Lawctopus Law School's free and open webinar on how to draft a legal notice. My name is Suvarna Dubey. I am a learning manager here at Lawctopus, and I handle the litigation basics course here. As you already know, one of the most important skill sets we need as lawyers is legal drafting. And one of the first and one of the most relevant documents that you must know how to draft as lawyers is a legal notice. Sending a legal notice marks the incipience of any legal proceeding, which is why today we have with us Mr. Tushar Giri, who will be teaching you how to draft a good legal notice. Tushar is the founding partner of Kalp Law, which is a dispute resolution firm based in Delhi, and has associate offices in Bangalore, Chandigarh, and Shimla. His practice areas mainly relate to cases of constitutional law, administrative law, environmental law, and criminal law. Tushar, welcome. We're very excited to have you here today with us, and we're looking forward to learning from you a lot today in this session. Um, so, before we move forward, just a few things. I know that a lot of you would have a lot of questions during this webinar, so please make sure that you put them in the chat box and in the Q&A box, wherever you prefer, anywhere. I think we would actually urge you to put it in the question and answer box. But if you can't find it, you can put it in the chat box as well. Also, if I could, are we audible? Can everyone hear us? Can you put it in the chat box quickly so that we know that we're audible? Okay, that's great. Thank you so much. Thank you. Thank you so much for your response. Please make sure that you put your questions in because we'd love to answer as many of them as possible. And yeah, I think we can get started. So welcome, Tushar. And the first thing that we all want to know, and we would probably, I think it will be best if we start with this. What is the significance of a legal notice?
Well, firstly, thank you so much, Suvarna, for calling me here to give me this opportunity to try to help other people as far as today's topic of legal notice is concerned. And so let us begin by your first question, which is, what is the significance of legal notice? Well, many people misunderstand the legal notice to think that it means a notice sent by a lawyer, which is certainly not so. The case is that legal notice is a formal communication by one party to another party, merely informing or intimating the other party about the first party's intention to commence legal proceedings. That is all that is in a legal notice. Now, there are various kinds of legal notices. We will delve into that as we go forward into this lecture. But the significance of a legal notice is that pre-litigation, a formal communication between the parties, where the relief, whatever is the relief that I am seeking, what is the dispute between the parties, and how we can settle it. That is what a legal notice is. Legal notice, there are some legal notices which are statutory in nature. There is a legal notice requirement in Civil Procedure Code. There is a legal demand notice requirement in the Negotiable Instruments Act, etc., etc. But legal notice, if it has to be summed up, it is a comprehensive brief of the facts about your grievance and the options for redressal of that grievance. And if your grievance is not redressed, your intimation to institute legal proceedings. These three things are basically the markers of a legal notice. And that is the significance of a legal notice. Legal notice significance, point number one, is that it helps in court proceedings. You see, it cuts the clutter. When you file pleadings in a civil suit, or you file a complaint in a court of Negotiable Instruments Act, or to the matter of fact, if you file a writ petition also in the High Court or in the Supreme Court, the first document that really helps in understanding the crux of the matter, that what is it that in a nutshell that you're seeking from the other party, can be drawn out or rather extracted from a legal notice. So that is one significance of a legal notice. On the other hand, as a measure of cost effectiveness, a legal notice many a times, or I would rather say 50% of the times, helps in reducing the cost of litigation, or rather helps in reducing the chances of litigation. You see, talking to another party on the phone or on emails or on WhatsApps and not, you know, making a serious case about your grievance to the other party does not really help you in some manner. Sometimes, when you send a formal communication to the other party about your grievance and how you seek to redress it, at those times, people and the other parties, whether they are individual or institutional clients, do think that it is better to settle the case, it is better to compromise between the parties than rather to go and approach a court of law or to face the heat in court tomorrow. So these are two aspects of about the significance of a legal notice. It helps in minimizing the chances of court proceedings, and on the other hand, if you do have to go to court, it helps you in reducing the clutter. Sometimes the response of the other side to your legal notice helps you in a proceeding or helps them in a proceeding. Sometimes their non-response to your legal notice is adversely seen in a court of law as well. So broadly speaking, this is the significance of a legal notice.
Let me remind you all, you're all free to put your questions in the Q&A box or the chat box, wherever you feel more comfortable. And I would urge you to start putting in your questions right now itself, because we would like to keep taking questions as and when we go forward, instead of just taking them towards the end, because then, we are not able to take all of the questions possible. Till then, Tushar, what are the laws that govern legal notices in India?
See, legal notice, Varna, is basically something that has flown out of common law principles of justice, equity, and good conscience. The idea of a legal notice is that you intimate the other side, as I just said some time back. That intimation gives the other party also an equal chance to settle the dispute before going to court. Broadly speaking, there are no laws that strictly govern a legal notice. Yes, there are requirements of statutory legal notices under the law. For example, there is a section 80 of the Code of Civil Procedure. If I may just read it, I'll just share my screen rather so that everybody else can also read the. Just give me a minute, please. Yeah. Is it visible? Yeah. So section 80 of the Code of Civil Procedure says, save as otherwise provided in subsection 2, no suits shall be instituted against the government, including the government of the state of Jammu and Kashmir, or against a public officer in respect of any act purporting to be done by such public officer in his official capacity until the expiration of 2 months next after notice in writing has been delivered or left at the office of. Then there's a A, B, C, D. We need not bother about it. So you see, so Code of Civil Procedure tells us that if we wish to institute a civil suit against a public officer in respect of any act which he has done in his official capacity, then we must serve him with a legal notice. And only after the expiration of 2 months of that service of that legal notice can we institute any civil suit against such officer. So just like that, there is also a requirement of a legal demand notice in section 138 of the Negotiable Instruments Act. I shall just read section 138 of Negotiable Instruments Act. It says dishonor of check for insufficiency, etc. of funds in the account. Where any check drawn by a person on an account maintained by him with a banker for payment of any amount of money to another person from out of that account for the discharge in whole or in part of any debt or other liability is returned to the bank unpaid, either because of the amount of money standing to the credit of that account is insufficient to honor the check, or that it exceeds the amount arranged to be paid from the account by an agreement made by the bank, such person shall be deemed to have committed an offence and shall, without prejudice to any other provision of this Act, be punished with imprisonment for a term or with fine, etc., etc. Now, please read the proviso. Provided that nothing contained in this section shall apply unless the check has been presented to the bank within a period of 6 months from the date of such and such. B. The payee or the holder in due course of the check, as the case may be, makes a demand for the payment of the said amount of money by giving a notice. So section 138 subsection B, or rather subsection or subclause B of the proviso, stipulates that the holder of the check must make a demand for the payment of the said amount of money by giving a notice. In the next section, I'll also be showing you a notice, a demand, legal demand notice under section 138 of the Negotiable Instruments Act, which will also make you understand that what is this demand and what is this said amount of money that a holder of a check must send to the other person. So just like this, there are some other sections in some other acts as well, which govern a legal notice. But if the question is that is there any rule, regulation, or any stipulation, statutory or otherwise, that tells you in what manner a legal notice has to be drafted or made, then the answer is no. There are some statutory notices and there are some notices that you must send as a word of caution, as a measure of cost effectiveness. But there is no legal requirement otherwise than statutorily provided in some acts to send legal notices. Sometimes, not only in Negotiable Instruments Act, or you see in civil suits that govern section 80 of the Code of Civil Procedure, so many times we see in high courts and in Supreme Courts, the first question that the bench asks the petitioner is that have you made a representation? This representation obviously somewhere broadly is on the contours of a legal notice, where you intimate the government or the public authority or the public body that if these are your grievances and if these grievances are not properly addressed to, then you will move to the court. So many a times writ petitions are disposed of or rather dismissed on the first day itself for want of representation by the petitioner. So there are no rules guiding those representations or legal notices. But as a matter of common law principle, as a matter of justice, equity, and good conscience, legal notices are somehow ingrained into our legal system. If anybody has any questions, I can answer them.
Tushar, one question that I'm seeing multiple people have asked is sending a legal notice mandatory?
Sending a legal notice, if it's mandatory, like I just said, that it depends. For example, if you're holding a check which has bounced, it has been dishonored, then yes, before initiating a complaint under section 138 of the Negotiable Instruments Act or section 141 of the Negotiable Instruments Act, you must send a legal notice. Just like I just illustrated in section 80 of Code of Civil Procedure, if you are instituting a civil suit against a public officer who is doing an act which he did in his official capacity, then you must send him a legal notice. Similarly, there are some proceedings that are initiated before the Armed Forces Tribunal, which cannot be initiated without you sending a representation or a legal notice. So it depends on case-to-case basis. For example, if you want to institute a civil suit against your neighbor and you are a private party and he's a private party, it's a suit for declaration or possession or anything, then it is not a legal requirement that you send a legal notice.
Tushar, there's one more question which is on similar lines. What about for criminal cases? Is sending a legal notice compulsory?
See, in a criminal case, sending of a legal notice will not arise because you see, a private party's job in in a criminal proceeding ends at registering a complaint. The moment either you are submitting a complaint to the magistrate's court or you're submitting a complaint in a police station. After that, it is in the hands of the state, the prosecution as we call it. And it is between them and the accused. So there is no requirement of sending a legal notice in criminal cases as such.
Tushar, there's another question. How many types of or how many categories of legal notices exist?
Well, broadly, they can be legal notices of all kinds, as many kinds as there are civil suits. There are civil suits for recovery of dues. There are civil suits for, declaration, civil suits for injunction. There are civil suits for cease and desist under the, Trademark Act, Copyright Act, etc., etc. So, as many as civil proceedings there are in our system, there can be as many legal notices, broadly speaking.
Tushar, there's one more question. Can a court refuse to entertain a plaint if a legal notice has not been served?
Only and only if it is statutorily mandated that you send a legal notice. See, if, for example, if you don't send a legal demand notice before filing a complaint for check bounce, the court will not take cognizance of your complaint. Because simpliciter dishonoring of check is not an offense. As we just read, the offense is dishonoring of check, sending of legal demand notice within 30 days of that dishonoring of check by you to the person who gave you the check, and non-payment of money within 15 days of that receipt of that demand notice. Only when all these three constituents are met can an offense under 138 of Negotiable Instruments Act can be deemed to have been committed. So yes, wherever it is mandatory statutorily, you must send a legal notice, but not otherwise.
So, Tushar, what happens if a person has no time to send the legal notice because maybe period of limitation is expiring?
Period of limitation is expiring. You have two options. If it is mandatory statutorily that you must send the legal notice, and if you've crossed the limitation period, then you must send it, because there is still a scope that in limitation, at least in civil proceedings, you can still condone that delay. The court does have the power to condone the delay. But if you don't send the legal notice, and let's say you institute a civil suit against a public servant or a public officer, then on the first day itself, not on the first day, but your suit can be dismissed on preliminary grounds for want of legal notice.
Okay. So, Tushar, how is a legal notice drafted?
Different people have different ways of drafting a legal notice. Some people make it a very comprehensive legal notice. Some people like to do it in a very concise and crisp manner. So broadly, if I have to tell you, there are three basic elements of any legal notice. One, it must have the description of the facts leading up to your grievance. Two, you must determine your grievance and how that grievance is to be redressed. That should be in very clear and concise manner set out in your legal notice. Three, options that you are willing to take. Options, there are two options. One option is for mutual settlement of your issues or the dispute between the parties. And the other option is that what options you are willing to take if there is no settlement of the dispute. These are three basic elements. In whatever manner you wish to draft your legal notices, these three elements must be there. Now, how does a legal notice start? A legal notice starts by introduction of your client, laying out of the facts. I like to do it, and many seniors from whom I have learned like to do it as simple as possible, crystallizing the factum of the dispute. The idea is not necessarily to threaten somebody. You see, many a times people mistake legal notices to be a measure of arm twisting people. what that usually does is it plays into the psyche of the other party. And so many times, because of bruised egos or because of being very defensive, people approach another advocate or sometimes approach another advocate with the intent to fight in court, which certainly is not the broadly the idea of a legal notice. The idea of a legal notice must be that you must spell it out very decisively your intention to settle the dispute. The idea is not to threaten them that you will institute proceedings in what manner and in how many courts. The idea is that your settlement, your intention for settlement must be spelled out very decisively. You must lay out the possible avenues that your client shall utilize should the dispute be settled or not settled amicably. And then, as we just said, that depending on whether or not the legal notice is required statutorily, the constituents of that legal notice will change. Now, what I will do is, I will now share my screen. There are 4 kinds of legal notices which I will try to show to you today. One is going to be a cease and desist. One is going to be a legal demand notice under Negotiable Instruments Act. One is going to be a legal notice for recovery of dues. And one is going to be a legal notice for termination of a contract. So I'll just share my screen.
I can see that there are a lot of procedural questions here as well.
Okay.
I will be addressing some of those towards the end. We'll focus on only the questions that are strictly related to legal notices. Tushar is going to address all of those. Procedural questions which are further, I'll address them towards the end of this webinar when I'll be talking about the litigation basics course here that we have at Lawctopus. Tushar, please go ahead.
Yeah. I hope you can see my screen.
Yes.
So first we'll begin with the legal notice of cease and desist. Many of you might be thinking what cease and desist is. Well, this is a case where there was a company whose employees had left their employment, or rather terminated their employment prematurely with our clients. And after the premature termination of the employment with our clients got to know that they were working with a competitor firm and they had disclosed their confidential secrets and business secrets to the other firm. So before they had joined employment with our client, they had signed multiple contracts, as is the case. And for breach of those contracts and for unfair business practices, we sent them a cease and desist notice. So as you can see, on top is usually the letterhead of the law firm, or if you are an individual advocate, your letterhead on top. Here must be clearly spelled out on in whatever manner you are sending the legal notices. See, this is very essential because many a time receipt of legal notices are disputed in court, saying that we did not receive it, the person was not on the address, etc., etc. So you must clearly describe here in whatever modes and in however manner you are sending the legal notice. Then it's usual the date, to whomsoever, email, your subject. For example, the subject here is breach of contract, theft of confidential information, and infringement of copyright. Dear sir, we write on behalf of our client ABC, a company incorporated under Companies Act 2013, hereinafter referred to as our client. We are under instructions from our client to address you as follows. Now I'll just pause here, that this is a common thread in all legal notices in whatever manner you write them. Your first paragraph must have 2 things. A very short description of your client. If it is an individual client, then description of whatever your client does or wherever he stays or in his usual requirements. Second, you must definitely and definitely under all circumstances in the first paragraph, write that you are under instructions from your client to address you as follows. This is my advice to everybody, that whenever you send a legal notice to anybody, under instructions from your client, please have those instructions in written somewhere, because you never know tomorrow how things might pan out. You're a professional, you must, under all circumstances, have an official memorandum of instructions that have been issued. So then we move on. Then first paragraph is, our client is a company founded by Mr. XYZ in the year, etc., and is engaged in the business offering services, etc., etc. So in the first paragraph, you're broadly laying it out in a more broader sense. You're laying it out in where your client works, in whatever field, and it was founded by whom, and your general goodwill in the market in this case. Over the course of so many years of operations in the industry, our client has spent a substantial amount of money on its research and development division to create its valuable intellectual properties. As our client operates in the highly competitive business space, it has always prioritized the protection of its confidential information, trade secrets, and proprietary data from any unauthorized disclosure and divergence. Any act of unauthorized dissemination of a client's intellectual properties, including its confidential and sensitive information and or trade secrets to any third party by its former or present employees, contractor, business associates, etc., therefore not only amounts to infringement of our client's legal rights, but also amounts to criminal act of data theft, breach of contract, and unfair trade practices. Such use is bound to put our client's interest in jeopardy by leading its third-party competitors to cause our client wrongful loss while causing themselves a wrongful gain. So what has happened in this legal notice is that in the first 2-3 paragraphs, you have laid it out about a general description of your client and its business. In the third paragraph, in one paragraph, very concisely, you have mentioned that you know what the crux of the matter is and where it can lead to. So you just let that person know that whatever his acts have been would lead to whatever consequences. Breach of trust, criminal action, action under whatever act, all of that is spelled out very clearly in paragraph number 3. Then you start with the facts. Paragraph number 4, you were appointed on such and such date on such and such position. Furthermore, your employment was also governed by the terms and conditions of employment agreement dated such and such. As per your engagement, you and our client had also entered into a non-disclosure agreement and non-compete agreement, both dated such and such. Then you lay out the facts. Recently, in the late January 2022, our client was shocked to learn that you have taken a competing role at a company with the business substantially similar and competitive with the business of our client, for which you were substantially engaged with our client during your term of employment. It is pertinent to point out that you have engaged in this employment in less than such and such months of termination of your contract dated such and such date with our client. Thus, the said act of yours clearly amounts to breach of your obligation inter alia under the non-compete agreement entered between you and our client, where you expressly agreed not to directly or indirectly compete with the business of the company and its successors, and assigns during the period of employment and for a period of 3 years following termination of employment, and notwithstanding the cause or reason for termination. Then in the 5th paragraph, what you have done is, I have merged the facts of whatever breach was done by the employee and whatever consequences that follow, that we had spelled out in the 3rd paragraph. That during the term of your employment, you had access to our client's most sensitive and confidential information, including the access to technical and business information such as computer programs, research projects, customer lists, financial data, marketing and merchandising system. Therefore, we strongly believe that you have divulged the aforesaid confidential and proprietary material to a competitor of our client. That despite the fact that you have signed a non-disclosure agreement, non-compete agreement, and provided an undertaking to our client in terms of clause 2 of such and such declaration on such and such date, that you shall not during or at any time after the termination of employment with the company, use for yourself or for others, or disclose or divulge to others, including future employees, any trade secrets, confidential information, or any other proprietary data of the company in violation of the agreement. That your act of terminating the employment with our client renders you liable. Now you're telling him the consequences in detail. The consequences of his breach in detail are in para number 8. That your act of terminating the employment with our client renders you liable to reimbursement of costs in terms of clause 14.6 of the terms and conditions of the employment agreement dated such and such, wherein it was agreed by you that in the event that the employee decides to leave the company's employment within 2 years from the effective date of this agreement, the employee agrees to reimburse the company an amount equal to the expenses incurred by the company in training the employee for the position, including but not limited to in-house training, travel, and accommodation expenses. So I don't want students to be very overburdened by all, some words here and there. These are words that have been directly taken from these contracts and agreements. So when these agreements and contracts which have been supposedly breached, when they are in front of you, you can use those terms as is basis from those agreements into your legal notice. But in a nutshell, what you are saying is that you have breached such and such clause, what that clause says, and what is the consequence that flows from breach of that clause. In para number 9, because now you want to explain to him that what are the clauses in various declarations, agreements, and contracts which he has breached. So para number 9 is purpose is just that your unlawful acts are evidently in bad faith and clearly amount to the offenses of data theft of our clients' confidential information and trade secrets, and the infringement of our clients' legal rights in intellectual property. Additionally, the said act also amounts to the violation of your contractual obligations under various agreements entered between you and our client over the course of years, which are inter alia as reproduced herein below. And then you spell out in these Roman numerals what are the breaches of specific clauses. Para number 10. Therefore, in view of the aforesaid breaches of your legal obligations and as per the terms of the agreement entered by you with our client will have the right to recover damages from you. Further, our client is well within its legal rights. Sorry, I just jumped. Furthermore, our client is well within its legal rights to institute civil as well as criminal proceedings against you in a court of law, entirely at your risk and peril for such remedies as available to them under law. Now, this is that you can say sine qua non for a legal notice. Your intention to institute legal proceedings against the other party must be spelled out in the legal notice. So you're letting the other person know that because of certain breaches that have been committed by them, you would be well within your right to institute civil and criminal proceedings or whatever remedies that your client has as per law. But then is the question of intent, the intent to settle the dispute. You see here now. However, with a view to amicably resolve the matter, our client has deemed it fair to put to you on last and final notice of their rights, giving you an opportunity to immediately seize, use, and disclosure of our client's confidential and proprietary information and trade secrets to our client's competitors. Accordingly, our client has instructed us to issue you this notice, calling upon you to immediately comply with the following conditions. Now, these conditions which are written below are in detail of what these highlighted portion is. This highlighted portion is the crux of the intention of this legal dispute. So just to rewind, it is your client's description, then what consequences that follow from breaches of generally speaking of the breaches of the contracts between the parties, the facts of the dispute, laying it out in detail about what consequences follow upon the other party to whom you are, the addressee to whom you are sending the legal notice to, your intention to institute legal proceedings, and then your intention to amicably resolve the matter, provided or subject to certain things that the other person must do. And in this legal notice, the other thing is to immediately cease use and disclosure of our clients' confidential and proprietary information and trade secrets to our clients' competitors. Then you will see below that it is just in detail of what has been said in this highlighted portion. Immediately cease and desist from using and disclosing our clients' confidential and proprietary information and trade secrets to any third party amounting to infringement of our clients' legal rights and breach of your contractual obligations as mentioned in such and such. Erase, destroy all confidential and proprietary information and intellectual property of our client, including but not limited to, etc., etc., etc. Delivery up of all the confidential and proprietary information and intellectual property of our client in your possession, including but not limited to, etc., etc., etc. Immediately tender resignation from your current engagement with your current employer and cease and desist from joining them or any other such third party for the agreed duration as per the paragraph number 1 of non-compete agreement dated such and such. And last is payment of money towards damages as incurred by our client due to unlawful activities in breach of your contractual obligations to our client. Provide a formal undertaking to our client in the above terms in writing. In the end, you must write that you look forward to their prompt attention to this matter and you will await their response. Then you provide a time frame. Like in this case, in the last paragraph, it writes, and will await your response to this legal notice within 10 working days from the date of its receipt by you, failing which our client will be constrained to initiate such actions as contemplated under law to protect their legal rights. There must be your name, your signature, and I must also add as a word of caution for all advocates, you must write your enrollment numbers below your names. There are some BCI circulars that mandate that you must write your enrollment numbers. So if you're an advocate, apart from your letterhead and in the footer your address and etc., you must definitely write your enrollment number. So this is an example of a cease and desist legal notice. So this is an example of a cease and desist legal notice. There are some other examples as well. If there are some questions, I can answer them and then move on to the other legal notices.
There's a question here, Tushar, asking how much time does the receiving party have to reply to a legal notice?
Well, this is a very good question. So, I mean, if it is, for example, under the 138, Section 138 of Negotiable Instruments Act, then you have 15 days to reply to it or to take action. If it is under Section 80 of Code of Civil Procedure, then you have 2 months to reply to it or less than 2 months. So if it is statutorily mandated that you must send a legal notice, then they will most probably always be stipulated what the time is for them to respond to the legal notice. If your legal notice is not statutory in nature, in simpler terms, if I must say that if your legal notice is not an essential requirement under any law of any act, then you must you must give them a reasonable amount of time to reply. 10 days, 15 days, some people give 30 days. So it totally depends upon you then for a non-statutory legal notice.
Tushar, there's another question. Do we need to state remedial provisions in a legal notice?
Remedial provisions as in what you are willing to, I mean, what proceedings you are willing to institute against the other party. You see, it depends on your, I mean, whatever you wish to do. It depends on the briefs that you hold. If you wish to tell somebody that you're very serious about the dispute and you wish to institute a complaint, a criminal complaint in a police station, or you wish to institute a criminal complaint in a magistrate's court, then some people like to refer to it. But sometimes what happens is that because you don't mention all the remedies that are available to you, and let's say tomorrow you take some other remedy, it might have some adverse effect upon your that remedy which you have availed but not mentioned in your legal notice. So it is best mostly that you leave it little open-ended, that you are willing to take civil and criminal remedies that are available to you as per law.
Tushar, there's another question. In non-compoundable matters, can a legal notice still be sent?
In a non-compoundable matters, somebody will have to give me an example. In what sense? Non-compoundable matter in a criminal case, not necessarily.
Okay. And there's another question asking, how can one get better at writing a legal notice?
Only by practice, only by seeing other good notices. So many times when you start your practice, you learn how to write a good legal notice by receiving legal notices. Clients which come to you with the legal notices that are drafted by very good law firms, very good advocates, of very good clients. So when you read those legal notices, when you read a variety of legal notices, you get a good general sense of how different legal notices are.
One last question, Tushar. What happens if the other party does not respond in time?
If the other party does not respond in time, then it completely depends upon how good your case is. Sometimes people like to give a follow-up legal notice, another opportunity to somebody to settle the dispute. Some people on the next available day, on the expiry of that time period which you have given to the other party, institute a legal proceeding. So I'm sorry. So it completely depends upon the case and the facts in hand.
I think we can move forward, Tushar.
How much time do we have left, Suvarna?
We have 15 minutes.
We have 15 minutes. Okay,
Yeah.
I'll just show a 138 legal notice then. Let me share my screen again. So this is a legal notice under 138 of Negotiable Instruments Act. I will not repeat what I have stated earlier. There's a letterhead again, but again you have to tell on top by what measures and modes you are sending the legal notice. 2, date, subject, notice under section 138 of Negotiable Instruments Act for checks dishonored due to insufficient funds. Dear sir, under the instruction and authority from our client, hereinafter referred to as client, resident of etc., we serve upon you the following notice of demand under section 138 of NI Act. It is similar to what our introduction paragraph was in the cease and desist notice. You must mention the instructions and you must mention the name of your client. Then the facts. That you had entered into a lease agreement dated such and such with our client where you had agreed to take the lease on premises, etc., etc., etc. So these are all facts, bare necessary facts. What you have to essentially in paragraph number 4, which I am writing here, is this. You requested our client to further allow you to reside at the premises till you could arrange an alternative accommodation. Our client agreed to your request in terms of the lease deed entered between the parties. The rent for the month of May was paid by you in part, that is rupees such and such, which was delayed by a period of 34 days. At this point in time, you further requested that the rent for the month of May and June be reduced to such and such, considering the financial situation and the pandemic. Our client once again agreed to your request. You had also not cleared your previous outstanding dues for an amount of rupees such and such and such and such. In paragraph number 5, you vacated the premises on this date, and at that stage you issued 3 post-dated checks requiring the remaining rent, your electricity dues and dues payable towards RW. The details of the checks provided by you are mentioned as follows. Here is on the first column will be the check number. On the second column will be the amount. On the third column will be the date and the amount, and it was for which dues. So you see, in a 138 Negotiable Instruments Act demand notice, there are some things which are essential. These are essential as per the section itself. You must ensure that in your legal demand notice, you spell it out that the dues that are pending towards you by the accused are for a legally enforceable debt. So like in this case, I'm spelling it out very clearly that this was for payment of rent, payment for RWA charges, which a tenant was to pay to his or her landlady. Then you have to spell out that the check was dishonored on which date, at which bank and which branch. So paragraph number 6, 7 and 8 are for that. That when the aforesaid check bearing number such and such was presented by our client to the bank, that is HDFC Bank, the branch, for collection, same was returned unpaid on this date by the drawee bank with the reasons, remarks, insufficient funds. So what you're spelling out is that for what reason the check was dishonored, on which date it was dishonored, at which branch it was dishonored, and what was the check number that was dishonored. So these are essentials of 138 Negotiable Instruments Act. Then as we move forward, then we write that the aforesaid checks were issued by you in discharge of your legally existing liability on the date of issuance of the checks as has been detailed above. That on the account of the above facts, you are liable to be prosecuted under section 138 of the Negotiable Instruments Act as amended up to date, under which you are liable to be punished with imprisonment which may extend to 1 year or fine, etc., etc. So now you are again in the, like in the previous season desist notice, here you can just pick up, these are similarities between both the notices. You are laying out the facts. The here is the breach of that section, or the section in which he can be convicted, and the punishment or the consequences that will follow of that conviction. Paragraph number 11 is very important because a legal demand notice under section 138 will not be a proper notice if it is not a notice demanding the said amount. The section uses the word said amount. So you have to spell it out very clearly. What is the amount that you are seeking from the accused? Under the circumstances, we call upon you to make the payment of rupees 70,000, rupees 22,752, and rupees 15,936, being the principal amount of the aforesaid checks, along with interest at 18% per annum, till the time of actual payment within a period of 15 days from the date of receipt of this notice. These 15 days is not by way of my imagination or creation. These 15 days are statutorily stipulated in section 138 of the Negotiable Instruments Act. So then again you tell them about the consequences. And then again your name, your enrollment ID, and your address. So that is a legal demand notice under section 138 of the Negotiable Instruments Act. And those are the clear constituents that are required by law to be put into that notice.
Tushar, a very important question, and I think a couple of people have asked this. What are the ingredients of drafting a good legal notice?
The ingredients of drafting a good legal notice are that you trim the unnecessary facts. You have to separate the chaff from the grain. Your legal notice cannot be like a pleading in court where you don't leave out every aspect. As a lawyer, as an advocate, as a legal practitioner, it is your job to not be over-influenced by the unnecessary facts that a client sometimes might be swayed by. You must trim the unnecessary facts at the cost of reputation. I'll say it again, that you must cut the clutter. So that is one essential ingredient of writing a good legal notice. Another very important thing in writing a good legal notice is that you must not give any admissions that might prove to be harmful in court for you tomorrow. So if there is a weak point in your case and you think that it can cost you big time in litigation tomorrow, best is to avoid mentioning it. Do not write anything that can adversely affect the case of your client in court tomorrow. And third are being very precise, concise, and crisp. So in my opinion, if for everybody to take, these are the three things that are essential for drafting a good legal notice.
Tushar, there's another question. What is the amount of variance in terms of facts between a legal notice and a plaint?
Between a legal notice and a plaint, you see, plaint will have to explain limitation, plaint will have to explain jurisdiction, plaint will have to explain the cause of action, plaint will have to explain n number of things that are required in different proceedings. But in a legal notice, there is no requirement until unless it is mandatorily required, like in 138 of Negotiable Instruments Act. So a legal notice, so to say, a non-statutory legal notice, so to say, does not have a format. But a plaint most certainly does have a format in which it has to be filed in court. Those are the basic differences broadly.
Tushar, there's also it's more of a practice question, and multiple people have asked this, which is why I'm putting this to you. How do you charge? How does a lawyer charge for a legal notice?
How does a lawyer charge? I've seen lawyers charge nothing for legal notices, so they consider it pro bono as well. For some people, if their case, sometimes if it's a very high value transaction, and if it ultimately helps the client, so people charge around. I've seen 20, 25,000. I've seen people charge 50,000. I've seen people charge 5,000. There is no straight jacket answer for how much you charge for a legal notice. Just like a case. It's just like a case. Everybody in the profession charges different. Right.
I can see that there are some questions here about certificates for this webinar and a couple of other things. I'll be addressing all of that after this 1 hour. So post 6:30, I'll be addressing all of it. I'll also be telling you more about the course that we have here at Lawctopus on litigation. But until then, until 6:30, we're going to only be taking up all of your queries and questions. There's another question, Tushar. How important is the language that you put in a legal notice?
Um, uh, as far as all pleadings go in court or all legal writings go, each one to their own. There are some people who use a lot of flowery languages. There are some people who use very simple languages. But what is necessary is that you use some terms or legal terms that are basic requirements to not create any confusion. If 138 Negotiable Instruments Act calls for legally enforceable debt, then you must write legally enforceable debt. I mean, this is as a matter of advice. If some act talks about dues, then you must say dues and not use any other word for it or any synonym for it. So as far as language goes, I mean, I like to keep it as simple as possible, and I like to keep it similar or same to the agreements, contracts, declaration, emails that have been exchanged between the parties. So it helps in understanding, and it helps in also the point of reference in very voluminous cases. Yeah.
There's another question, Tushar. How do you rectify errors in a legal notice?
Rectification of errors in legal notice. Sometimes people send a supplementary legal notice and withdraw the previous legal notice. So you always have that option. You can do that. And tomorrow, if that first legal notice where you have committed an error, let's say it's not a typographical error, it's an error which is very manifestly dangerous to the case of your client. So then, in that sense, you formally withdraw that legal notice and send another legal notice. That has to be a way out.
Tushar, as a matter of practice, do you show the legal notice to the client before sending it?
Yes. As a matter of practice, we show all pleadings, everything that goes out under instructions of anybody to them.
There's another question. Can a legal notice be sent to the government?
To the government?
Yes,
it can be sent. No doubt about it. If the thumb rule is, if you can institute a case against the government, you can definitely send a legal notice to the government.
Okay. Do we always have to mention the costs in a legal notice, the compensation that we're asking for? Does that always have to be mentioned?
if your relief is not monetary in nature, then there is no point mentioning any cost. Let us say you want somebody to not disturb you, to not to not encroach upon your property, or you are seeking a relief of injunction for somebody to stop doing something, to prohibit them. So in those cases, it is not necessary that you mention any cost or compensation in those legal notices. Some people do, as a matter of, you can say, to threaten them, to scare them off, so that monetary consequences will follow. But if you, my advice is that if it is not monetary in nature, then do not mention it. Yeah.
Tushar, what would you suggest? How should they practice and hone their legal drafting skills?
Best way would be to try and read as many legal notices available. And it is not that legal notices are very different from pleadings in court. There is a way of legal writing. There's a form in which broadly all lawyers worth their salt file their pleadings in court, whether these are pleadings in civil suits, whether those are complaints to the police station magistrates, or whether they are writ petitions. All original side proceedings, there is there is a pattern to this drafting. It is the same pattern that is picked up and applied to a legal notice. So the more you read legal briefs, the more better equipped you will be to write legal notices, and it will help you immensely in honing your skills as well.
Is there any website that you would recommend, or any book where people can go through legal notices?
Books, there are many, but off the cuff, I can't remember any book. But websites, I don't think so.
Okay. I will eventually speak to Tushar again about this, and whatever book he recommends or whatever website he recommends, I will put that in the WhatsApp group that I've just shared the link to, so that I can give you some resources regarding that. So before we move to the next segment of this webinar, thank you so much, Tushar, for this absolutely insightful and helpful webinar that you on all the information that you shared with us today. I know that everyone here has learned so much. I think almost all the participants who joined from the beginning have stayed here till the very end. So thank you so much for teaching us, for helping us know so much today. And we look forward to doing another webinar with you very soon. But thank you so much, Tushar, for this, for taking out time.
Thank you so much. Thank you, everybody.
Thank you so much, Tushar. Thank you so much for taking out time from your schedule. Okay, as I told you all, we will be moving to the next segment of this webinar. So as I told you, I'll be telling you a bit about the litigation basics course that we have here at Lawctopus. I'll also be speaking to you about the certificates. I know that a lot of you wish to have those. And although I cannot emphasize enough that this webinar is, we wanted you to attend it for the knowledge and not for the certificates, but we know that a lot of you might require them for your internships, for your college, for your CVs. So I'll be talking to you about that as well. But before that, I will be telling you a bit about the course that we have at Lawctopus, because I know that a lot of you are law students and a lot of you are budding litigators, and eventually, of course, you will be drafting and you will be working in courts and understanding court procedures. So just to help you and assist you on that learning journey of yours, we have a course here at Lawctopus for you. Let me share my screen with you once. I hope all of you have joined the WhatsApp group that I had sent you the link to. I'll also send you I'll send you the link to the feedback form there as well. I've sent the feedback form here too, but I'll send it again in the group. Just give me 1 second. I'll send you here it is. I put it in the chat box, the feedback form. Please fill it. It's a feedback form. It's an expression of interest form. Please do fill it. It helps us know what you thought about the webinar. I'll also send the link to the group. I'll also be sharing any resource that I get to know of from Tushar on the group. So please do join it. I've shared the group, the link to the group again. Please join it if you still haven't. And I'll share my screen so that I can show you just I can give you a brief idea about the course that we have here. Just give me a second. Yeah, I hope my screen is visible to all of you. Can you all see it? Can you put it in the chat box so that I know? Okay. Yeah. Okay, cool. Thank you so much. Thank you so much for letting me know. So as I already told you, we have a course here at Lawctopus. It's called Litigation Basics. I handle this course, which is why I'm here telling you about it. So first and foremost, why this course? This course is basically to teach you about, so what we aim here with this course is that we try to help you understand whatever goes on within your probably, first 5 or 6 months once you join a litigation office. So all that you learn there, we teach you right here before you go there, so that, you don't feel lost, and that you're a lot more aware and a lot more prepared to be there. So we teach you about court proceedings, both civil and criminal. We teach you about how to read big, massive case files. We teach you how to summarize them, how to make a case brief, which is an extremely important skill that you will need all your life as lawyers. Whether you work for someone or you work by yourself in a litigation office, you will need to know how to draft a case brief, how to make a case brief. And that's something that we teach you in this course. As you can see on the screen, it's a core skill. Making a case brief is a core skill that litigators need, especially in the initial years of your career. And eventually, of course, it becomes more of a habit, and you're able to draft and you're able to make these case briefs a lot more easily, and you're able to understand cases inside out a lot more easily. The idea of a case brief is that, so that, once you've read a file, you can create a case brief, you can make a case brief, and then on the basis of that, you do not have to read that file again and again, time and again. Because what happens is, at times, today you have a date of hearing, and then the next date of hearing is probably 6 months from now. This used to happen all the time when I was working in a litigation office. I worked with an advocate on record, and this used to happen very often, that we would be doing it, we'd be going for these for a date of hearing today, and then we wouldn't get a date of hearing anytime soon, and then 6-7 months later we'll have to go again. So instead of having to read the entire case file, we would just read the case brief and go, and we would know whatever was there in the case, and we would be able to recall everything about the case again. And that's the whole idea behind this. I can see that there are a lot of questions in the chat box, yeah, I will address any question that's there in the chat box towards the end of this. Please be patient. Okay, so a couple of things that, of course, your skills that you need for litigation. One is, of course, your knowledge of law. There's practice and procedure. There's research skills. There's drafting legal documents. And we had this entire webinar on drafting one of the most important legal documents that there is. And of course, there's advocacy skills, there's networking and soft skills, again, very important. And of course, your knowledge on the matter. So this whole course that we have here with us, we'll teach you how to read case files, how to navigate through massive case files and convert them into proper notes, short notes, how to read, judgments, how to be well versed in proceedings of court, both civil and criminal. There's one entire live session only focused on criminal and civil proceedings. We'll give you bonus material on drafting bail applications. This webinar will also be a part of that course, so that you can go through this webinar again and again and again, as many times as you like. We'll help you understand how to be well prepared in courts, how to ease the burden of your seniors, and just how to be able to do meaningful work in a litigation office or in a corporate office as well. As long as if you're in the litigation team, or if drafting, or if court proceedings are an important part of that. So this course is completely online. It has live lectures and assignments. Then there's it's completely online, so you won't have to come anywhere. no offline issues at all. It has text-based modules, which basically means that there are reading resources and they have been prepared by industry experts. Some really fine advocates have prepared and have created this course and developed this course to teach you about litigation, like right from the basics, like right from the beginning, right from ground zero. Then, of course, we have an online based doubt resolution forum. So you can just type your queries there and we'll get back to you on those. You can also ask your queries in live sessions as much as you want. There is one live session that we do in a week, and it's on Sunday morning. So, they will not clash with your work. You will not have to put in too much time into it either. At max, you need to spend probably 3 hours a week on this course, not more than that. So just one live session a week. And there is one particular week where we have no live sessions and you only have to complete the assignment, which is to draft a case brief based on a PIL that we will provide you. And everything will be taught to you. Please don't worry about that. We will first teach you everything and only then will we be giving you the assignment to do. An assignment, of course, as I've told you, and you get personal feedback on the assignment. Your faculty will give you, the person who will be teaching you the course will be giving you feedback as well, to make sure that, and personal feedback. We will not give you any generic feedback that these are the things that you should be doing. We'll be going through your entire assignment, spending time on it, and give you feedback as to, what was good, what wasn't, what can be improved. So it's a very interactive course, and it's a course that is aimed at making you do better in the area of litigation. As I've said, it's completely online and self-paced. It's for 1.5 months only, so 6 weeks, out of which only 5 weeks will have one live session each week, and that's it. And at the end of it, if you complete the course, that is, if you submit your assignment and you pass, you get a certificate of completion. We also give you 2 chances to complete your assignment, like 2 chances to pass your assignment. So don't worry about that. We've never had an issue with this. Or everyone who submits an assignment at the end of it does receive a certificate of completion. If you do really well, you will also get a letter of a merit certificate, which is signed and written by the CEO of Lawctopus. So that is also there. So as I've already told you, we have text modules for you. We have recorded video lectures. We have live classes, which are 2 hours long each, once a week. And there is a compulsory assignment. We have some MCQs as well, which you can do at your own pace. They have no bearing on your certificate. You can do them whenever you like. So we have 4 MCQs for you. And we have 4 live sessions, I've already told you. And we have career webinars as well. So we know that, CV making and LinkedIn profile building and applying for foreign LLMs. We know that these are things that interest law students. So we make sure that we do all of these, and we provide you with webinars on all of these as a part of this course. So Vikhyat is the one who will teach you this course. He is an advocate in the High Court of Delhi. He is a criminal as well as civil advocate. He specializes in criminal matters. He's one of the finest teachers we have here at Lawctopus, so you're going to have a great time learning from him. A couple of add-on benefits is, if you do exceptionally well during this course, we will help you with internship opportunities. So if you receive an orange grade, we will definitely help you out, because Lawctopus partners with a lot of organizations and lawyers, and we can help you out with that. We'll also give you an opportunity to publish on Lawctopus's journal, which is called Academic. You can also be a marketing intern for Lawctopus, and CV advice and career counseling is something that we always provide to our learners. So this is the course. If you do wish to, do this course, if you do want to know more and learn more about litigation, this is the course for you. I think the cost of this course is 3,300, but we're giving you, all the people who attended this webinar, we're giving you a coupon code. It's called LBW10. Please use it. If you do decide to purchase the course, please don't pay the complete fee. Please use this course. And I think after using, this code, and after using this code, I think the cost will be around 2,900 something. So it will be a lot less. Like it's around 3,300 or something, and it will come down to 2,900. So less than 3,000. But if you do wish to do this course, please do use this coupon code. It's LBW. I'll also put this coupon code in the WhatsApp group, so that so that you don't forget about it. And if you do decide to purchase this course, please use it. This coupon code is valid till Friday. So please make sure that if you do decide to buy the course, you do use this coupon. We'll try to push it to Saturday. I will speak to my senior management and I'll definitely try to push it so that, by Saturday you can have ample time. You can discuss this with your parents, or, if that is something that you need to do. And if you are genuinely interested in the course, then do use this coupon code. Please don't pay the full amount. Please use this. We have this right now, and we made this coupon code just for the people who were going to be attending this webinar, because we know how important learning about litigation is for you, because that is the reason why you guys are here, and you've taken out time from your schedules. And I know all of you are busy as well. A lot of you must have exams coming in soon as well. So please do use this coupon code, and we'll I would love to see a lot of you there in the course. Also, if you're worried and if you think that your exams are coming soon or something, if you join the course now by using this coupon code, we can also eventually shift you to a future batch. So you wouldn't have to worry about that. If, after the first session, you feel that it's becoming a lot for you, and that at the moment you don't want to do it and you want to do it probably a month later, we can do that. We can shift you to the May batch. So you don't have to worry about anything. But this coupon code that gives you a 10% waiver is available only right now. So please make sure that you use it if you decide to purchase the course. Otherwise, you'll have to purchase it at full amount. If you have any queries, please do put it in the chat box. The classes are going to start, I think, from 3rd April or something. So 3rd April to, it's basically from 1st April to 15th May, because it's a 6-week long course. So yeah, you can if you want to do the course, you can join in. If after maybe after the first week of April you think that you have exams or there's something else going on and you wouldn't be able to do it, we can definitely, as I told you, we can shift you to the next batch that is going to start on the next batch that will start in May or June, whenever it does, and we'll push you and we'll shift you to that, so you don't have to worry. But the coupon code is valid only at the moment, so please do use it if you decide to do this course. Yeah, I'll tell you about the certificates as well. Although, as I already said to you, I've already told you this. Please do note down if you are interested in the course, please do note down the coupon code. It's LBW10, all in caps. Please make sure that you've noted this down somewhere. Do use it if you do decide to do the course. Okay, now comes, I'll put it in the chat box again. It's LBW10. Okay. Okay, now I'll tell you a bit about the certificate. As I've already said, we've actually put this in the post that we put out on Lawctopus, that certificates won't be provided, but we know that a lot of you do require certificates for your college and your internships and your CV. So there is we have a link. It's called razorpay.com/webinar certificates. What you can do is you can simply there's a logistics fee of rupees 100, because we have to go through certain processes for this. But all you need to do is you need to go to this website, and you have to simply you'll have to pay 100 rupees. You can choose whatever payment manner you wish to, and the certificate generation code is notice. That is what you have to put in. So there's a logistics fee which is 100 rupees, and the code, the certificate generation code is notice. So just put that in and you will be fine. But yeah, there is unfortunately a fee for this, because this is not in our control. This is something that we do through a certain app, so it's from them. Yes, it's notice. It's in all caps. Just put it there. That is the certificate generation code. I've put the link here. I'll also share the link on the WhatsApp group. So if a certificate is something that you really require and you wish to have, then you can just use it. So the recording of this session 1 is going to be a part of the course, as I've already told you. And secondly, we will eventually upload this on on our YouTube channel. Lawctopus has a YouTube channel. Please do check it out. Just type Lawctopus on YouTube and you will find it. So we upload all the webinars that we do there. So this will also eventually be uploaded, but I'm not sure when will it be uploaded. So yeah, that's hi, Siddhi, I can see that you've asked a question. Siddhi, see, the thing is, for all those people who attended this webinar from the beginning to the end, we had decided to give this coupon code for the course as a waiver, because we know that you guys are really, really interested in this. I will, in the group, put down some recommendations, recommended books, or websites that Tushar would recommend. I would definitely put those there on the WhatsApp group. That is also for people who've stayed throughout this this webinar and who've actually taken out time to join the group. So we'll make sure that we do that. But yeah, so this is the certificate generation. The webinar is called how to draft a legal notice. That's it. It's called Lawctopus Law School's free and open webinar on how to draft a legal notice. I'll put the Razorpay link here again. This is where you can this is how you can generate your certificates. I'll put it in the chat box. I'll also put it on the WhatsApp group. So don't worry if you're not able to find it here. Please do fill the feedback form. It's so important for us to receive your feedback. It's really it helps us a lot. It helps us for future webinars as well. We'll be able to do a lot more with that. But yeah, that's about it. If you do decide to do the course, please check it out here. Can you get the certificate? You will get the certificate online. That is how it will happen. The moment I think you make the payment, it just generates a certificate on its own or something. I'm not exactly sure about the process, but it will happen online only. You won't like receive it via courier or whatever. I think it'll come to you. And if it hasn't already, then it will soon come. Don't worry about that. I know that you're all already a part of the group. Don't worry about it. Tasneem, who's our executive assistant, she handles this. I've already told her about this process and that we are using the code notice for this. So she'll definitely be making it and she'll send it to you. Thank you so much, guys, for the wonderful feedback. I can see that a lot of you are saying that the session was really nice. So thank you so much. It's a lot of effort that we put into this and a lot of time and energy that goes into this. So I'm really happy and I'm very grateful that you all enjoyed this session. So thank you so much for being here, for staying throughout this. I will put the course link again in the chat box. Please do check out the course. I've been handling this course for about a year. Trust me, I know the sort of impact it has had on the amount of knowledge that law students and few new lawyers, young lawyers have had, because this course is not only done by students, it's also done by young lawyers. Certificate course on contract drafting. There is a certificate course on contract drafting. Just type on Google Lawctopus contract drafting course. If you wish to do that, you can try it. Although this coupon code is only valid for the litigation basics course. But if you wish to do that course, please do go ahead. I actually did that course before joining Lawctopus back in 2019. So yeah, it's a great course. Please do check it out. After payment, when will we receive the certificate? I'm not exactly sure about the timeline, but very soon. I'm sure by tomorrow you'll definitely receive it. And yeah, don't worry about it. You will receive it. I will update you about this on the WhatsApp group as well. I know you're all there. I'm there as well in the group. Tasneem is also there. Tasneem is the one who handles this. I will ask her how much time this takes and she'll let me know. But yeah, there's an app and I think certain things happen there. I'm not exactly sure about the logistics, but I know that it won't take longer than a day. So don't worry about that. I'll ask Tasneem how much time it takes, and I'll inform you on the WhatsApp group. Yeah, Suyash, does that sound good? Okay, guys. So thank you so much for being a part of this webinar. I hope to see a lot of you soon in the litigation basics course. Yes, I will definitely text you any books or websites that Tushar suggests for sure. Please do check out the course as well. Do we have dates for June? At the moment we don't, but we can, like, if you join the course now, we can shift you to June. That's absolutely fine. Whenever whatever dates we'll have in June, it'll either start from 15th June probably, or 1st June, I'm not exactly sure, but we can always move you to a future batch. At least you would have used the course, and you would have used the coupon, and you wouldn't have to pay for the entire, like, you wouldn't have to pay the entire amount for it. So yeah, if you do decide to do it, do join it, because right now we have we have this waiver available. So yeah, and we can always move you to a future batch. That's never been a problem. We've done it for multiple learners, so that's not an issue at all. Okay, guys, so I will send you the rest of the details on the WhatsApp group. Please fill the feedback form. It will really, really help us. And yeah, hopefully I'll see a lot of you in the course as well. Bye-bye. Take care. Thank you so much for being here for an entire 1.5 hours. So thank you so much. Bye, guys. Take care.